Hi, I'm Maria Eva Suzy. I'm the principal at the Law Office of Maria Eva Suzy here in Gilroy. I'm here today to talk about part two of the new employment laws you need to know in 2024. This is a series of 3 videos. This is part two. Part one can be found on my YouTube. So today I'm going to go over cannabis use and the Fair Chance Act. And just a reminder, this is not to be treated as legal advice and it may be considered an advertisement in some jurisdictions. So here's an overview. I'm going to go over AB 2188 and SB 700. They were both effective January 1st of this year. And big picture is that there's additional protections for off-duty use of cannabis, and there have been amendments and expansions to the Fair Chance Act of 2023. So AB 2188, the new law provides that employers cannot discriminate in hiring, firing, or employment terms, or penalize a person for off-duty cannabis use away from the workplace, or results of an employer-required drug screening test that result in non-psychoactive cannabis metabolites in the employee's hair, blood, urine, or other bodily fluids. There are some distinctions here to note. So cannabis use is still considered federally unlawful. The new law, AB 2188, also does not allow employees to possess or use cannabis on the job, nor does it interfere with an employer's right to maintain a drug-free and alcohol-free workplace. AB 2188 also has a specific rule on pre-employment drug screens. So pre-employment, an employer can still refuse to hire an applicant based on scientifically valid pre-employment drug screening through methods that don't screen for non-psychoactive cannabis metabolites. So who is not protected by this law? So there's no protection for employees who work for construction trades or for positions that require federal background investigation or clearance, or employees or applicants with federally funded grants, benefits, licenses, or contracts that are subject to state or federal laws concerning drug screening. So now let's talk about the Fair Chance Act of 2024. This was effective January 1st of 2024, and this used to be called Ban the Box. So it's a push to encourage employers to give individuals with criminal histories a fair chance, and that includes evaluating certain factors and following a certain procedure when conducting background checks and when you result in, I guess, actual criminal histories. So, in the Fair Chance Act of 2023, so it started by regulating post-offer adverse actions based on an applicant's criminal history. And the 2024 Act regulates adverse actions as to ongoing employees, not just applicants, in connection to mergers, ownership changes, policy changes, and ongoing background checks. So in the Fair Chance Act of 2023, um, required that employer weigh the adverse action in 3 ways. There were only about 3 factors. So they had to consider or the nature and the gravity of the offense, the time between the offense and the completion of the sentence, the nature of the job sought. The employer had to provide written notice to the applicant before taking adverse action, and the employee had 5 business days to respond to provide mitigating factors for the employer's consideration. And the employer had to provide a written decision to post a criminal history check. So in 2024, um, the law added a provision that if the employee disclosed their criminal history up front, the employer could not consider the offense information received directly prior to a conditional offer. It also added a provision that employers cannot advertise on job descriptions that applicants with criminal histories would not be considered. It also expanded the procedure for taking adverse actions. It expanded the factors an employer must consider, and it expanded the mitigating factors an employee can offer. And we'll go over those. So, after the employer performs a background check and before the employer decides to take adverse action to an applicant or an ongoing employee, the employer must consider the following factors: the specific personal conduct of the individual in the conviction, the harm to the property or to people, the degree of harm, the permanence of harm, the context of the offense, whether a disability played a role, whether a reasonable accommodation would have prevented or mitigated the conviction, any existence of trauma, domestic violence, sexual assault, human trafficking, duress, or any other similar factors, the age when convicted, the time elapsed since the conviction and the time served, the duties of the job in question, the context of the conviction likely to recur in the workplace, and the degree of harm that occurred likely to occur in the workplace. So another enhancement of the 2024 law is the procedure for providing notice and how much time the employee has to respond. So in 2023, the law simply stated that an employee had 5 days to respond from the time the letter was sent. Now, the employee has 5 days to respond from the time the letter is deemed received, not from the date it is sent by the employer. Essentially, this incorporates the Code of Civil Procedure for mailing to determine when it is received. You have to add additional days to the 5 days based on whether it was sent electronically or by mail or overnight or by fax, which nobody uses nowadays. And so it's important to look that up. Excuse me. So another enhancement here is that the 2023 version did not enumerate factors for the employee, but just generally stated that the employee could submit mitigating factors after receiving a written decision of the intended action. So the 2024 law explicitly enumerates several factors an employee can offer as mitigating factors to plead a case why the employer should not take the adverse action. So it lists 11. One, the employment history before and after the conviction, the facts of the offense, whether there are self improvement efforts, whether community service has been performed, rehabilitation programs, bonded compliance and completion of parole, work education rehabilitation while incarcerated, employment history, community involvement now, other rehabilitative efforts, and the initial factors that I went over earlier as well. Essentially, this Fair Chance Act also prohibits employers from asking job applicants questions about their prior use of cannabis that resulted in criminal conviction. The new law prohibits an employer from using criminal history about an applicant or employee unless the employer is permitted to consider or inquire under a law. So that's it for today. It's a short one. If you have questions about these new laws, you can contact me here. And thank you for watching.